In a case where we're dealing with, I had a guy go in and there was a judgment issued in his case. There was a whole bunch of things. He went in as a trustee and we did a whole bunch of stuff, but in one of the communications I had him take and put "in re" on top of the court heading. He sent this into the court and that made it a private communication. All right, he did this with the judgment, and it made the judgment, it took the judgment from the public into the private now. He didn't accept it for value, "in re." Now what happened was, now the judgment issued in the public was now on the private side, and the other side couldn't use it. So what they went to now, what they did, they issued a notice of motion. Not a motion, a notice of motion, which is not a motion at all, "in re." So it was a private communication to the judge in the form of a motion, asking him to sign off on a memorandum of judgment. Now they weren't going to sign it, but they wanted the judge to sign off on this memorandum of judgment so that they could file that in the county court, and now they could collect on that judgment again. "In re" took it private. They could no longer use it on the public side, so now wanted to take and file a memorandum of judgment back into the public where now they could use it again. It's the same thing the IRS does, and that's the same thing we can now do. When we get done here, we issue this declaratory judgment, and when we're dealing with a bank, what we're doing is for $1 million or for a $100,000 loan, mortgage, we know that they took and they monetized the note, the mortgage agreement, and then they're collecting payments. All right? This covered the house. This was their bonus. This is additional extortion. And when we end up with a judgment, the way we do it here, we now end up with a judgment in amount of this. And because it was done in fraud, we ended up a judgment with that times 3. That's the process we do here. That's the process you're going to be doing. We end up with this declaratory judgment against the bank for 3 times the mortgage and the payments. And now we can take that judgment, a private judgment, and we can file a notice of lien in the county recorders or on a UCC3, and now you have a valid notice of lien against that bank. This is going to give us a lot of power, control over these banks. This is going to be a way to now we can take and enforce these judgments. It doesn't take very many of these notices of liens against the bank to really hurt them. That's where we're going to be going with this stuff in the near future. The notary certification is agreement of the parties. All right, we're sending them out of contract. We're sending them out of presentment. We're saying, here's my accusations. Here's the way I see this. I'm going to give you a chance to rebut it. And if you don't rebut it, then you agree. All right? The notary certification is a certification of an agreement between the parties or a contract, and therefore unreviewable. Same thing the IRS does to us. Now we know we can do this with the banks. That's not a problem anymore. But also, when we're doing a foreclosure, it appears that the courts are operating in collusion with the banks to take our homes. It appears that the courts can ignore all the rules, regulations, codes, statutes, court rulings, and opinions. And it is clear that when we enter the courts, we have no rights. All right? This is clear. Anytime you go in a courtroom, this is real clear. And it's clear that the banks, seemingly with the assistance of the courts, just run right over us. So let's analyze, what are these courts? What and who are they? These courts are administrative courts who gain their authority under Title V, the Administrative Procedures Act of 1946, and or the Judiciary Act of 1789. Now, 1789 is the year whenever the organic post office passed, or the Continental Congress passed the Judiciary Act, but they also established the seat of government, Washington, D.C., as a general post office. All right, as a general post office. The administrative courts were established for the purpose of being the watchdog over public offices so that if and when the American people had their private rights violated, they could file a complaint at no cost. So when they created a general post office, they knew all the agencies, that the government, would be no more than administrative agencies or corporations, all right, that had the potential of violating our rights. And boy, were they right. So the administrative courts, or all the courts today, were set up and established in 1789 along with the general post office so that when our private rights are violated, we could go in there and prosecute our grievance against these administrative agencies at no cost. But have they ever gone awry? These administrative courts were designed to give the administrative court the power of legislation, the power of the executive branch of government, to give them judicial power and authority. These administrative courts were authorized to disregard laws, case cites, Supreme Court decisions, statutes, codes, rules, regulations, and to change policy. Boy, they do that, don't they? They follow exactly what they were set up to do. Disregard everything. The problem is, they're not operating quite properly. The system was designed for use by the American people, not against the American people. All right? These administrative courts have jurisdiction only over administrative agencies and not over the American people, and were established as a vehicle for use by the American people to lodge and adjudicate grievances against administrative agencies, and gave the administrative courts the power and authority to make the corrections without the lengthy process of introducing or passing legislation. They were established for our purpose, to prevent these administrative agencies from violating our rights. They have absolutely no power and authority over us, over we the people. That is the common law courts, where there must be a harmed party. That's where we're supposed to be. This is for the administrative agencies.